Hello, everybody. This is Howard Klein. I'm an attorney focusing in commercial real estate and, in particular, landlord tenant matters. I don't see any comments yet. We had a little issue with comments and watching this webinar last week. Hopefully, that'll help. So, if you're watching this, please go to the comments section and type in that you can see it. You should be watching this on YouTube, and hopefully that will work well. So I'm going to move on now. It says that we're live, so hopefully we can do that. So again, what we're going to be talking about today is subleasing in a coronavirus world. And one of the things that I had, the reason why this topic came up is that I was reading in a number of different articles on how subleasing, in particular subleasing in office, has become such a significant portion of the market. I was reading in some instances and in some jurisdictions as high as 50%, in other jurisdictions as high as 25% of the entire market. So we thought it would be important to do this and figure out what's important and what's not important. So why don't I move on and give a few instructions here. So this is what we're going to be talking about. What should landlords and tenants try to accomplish when we're dealing with an assignment or sublease? And we're going to be dealing with both, and maybe I'll have Peter explain what the difference is from a practical perspective. What everyone should pay attention to, what the most relevant lease provisions. It's not just the assignment and sublease clause, but there are many other provisions that are affected by the assignment and sublease clause or affects the assignment and sublease. As I mentioned, we're going to talk about the difference between a sublease and assignment, and then we're going to talk about what the typical structure is, the type of documents that we tend to see. And this is an area where I tend to see a lot of errors because I get to see these documents after the fact. So Peter and I can talk about that a little bit more. So again, let's talk. I don't see any comments, so I'm a little bit concerned whether or not this is actually streaming live. I guess we'll find out, and I'll figure out what the problem is, but it should be streaming live. So if you would, everybody, if you're watching this live, please type in the comments where you're watching this from. That way I know whether or not anybody's watching this. That's number one. Number two, if you have any questions, I will get to the questions. Peter and I will get to the questions at a later time. I find that if the comments are flying in, I get distracted and I start pausing, and you'll see me get distracted. We are not giving legal advice. That's something very important. If you need legal advice, you can either contact me outside of the webinar, or if you would like, contact your own attorney, please. Don't take whatever we say and then start acting upon it. And to the extent, since I am an attorney, to the extent that it is considered attorney advertising, I'm letting you know this attorney advertising. If that bothers you, get off. That makes it simple. So why don't I introduce now Peter Morris and myself. Peter, you can open your eyes and wake up. Okay, Peter. Peter. Okay, Peter has frozen on me.
That's a second here. We'll
There you
get
are.
this worked out.
You're back. You look like you were sleeping.
I know.
What? Are you on wireless? Oh gosh.
I am. I'm on Ethernet, and for some reason, we seem to be cutting out. But I am on Ethernet.
Yeah.
So anyway, I'm Peter Morris. I'm with the Greenstead Consulting Group. We're an international commercial real estate advisory firm working with investors, developers, owners, and occupiers of commercial real estate all around the globe. I've had the great pleasure of working in such places as Canada, the United States, Colombia, Asia, and the Middle East. And we do all kinds of things for all kinds of people in the commercial real estate industry. So that's a little bit about us.
Well, great. Since I already mentioned myself, I think we'll move right on to the webinar. All right. So here we go. Peter, you want to move just a tad bit to your right?
You got it.
There you go. Perfect. So, Peter, if you would, why don't you start in with this? What should tenants consider when intending to assign or sublease?
Well, the first thing is to understand why you're doing it, obviously. And in the coronavirus environment, people are doing it in order to get out of the liabilities that they have. They may no longer find that the space, all of it or a part of it, is useful for them, and they want to limit their liabilities. So the first thing that they should consider is, why are we doing this? The second thing is they should also consider who they are assigning or subletting to, because there is some contingent liability from a financial standpoint that continues on. But the big thing you want to do by doing either an assignment or a sublet is giving up the cost of that space and the obligation to operate that space to another person. So in general terms, you want to limit your liability, both for the tenant and any guarantors that are on there, because if you get a very strong assignee or transferee or sublessee, then the likelihood of someone running after the guarantor is probably a lot less. Want to look at all of the lease provisions before you go and do the assignment or the sublease, because as Howard mentioned right off the top, there are provisions that will be affected by an assignment. You could lose some what I call tenant benefit clauses, because they could be personal to the original tenant. Now, in the case of a sublease, you don't necessarily lose those because the original tenant becomes a sub landlord. In the case of an assignment, very likely you could lose that, and then you end up in a negotiation in order to keep that. That could increase your costs or increase the cost of the assignee. And then you also have to consider, what are all the approvals that one has to go through in the assignment process? What does the landlord get to say in the approval? Must they act reasonably? Is it defined as to what reasonable is? Can they act in sole discretion? And so the landlord also might have a clause that says, just because you came and talked to me about an assignment or a sublease, I'll recapture the space. Now, whether or not they're actually going to do that right now is up in the air. But if they see that they have another entity that may be better for them, they may just say, you know what, I can up the rents and get a better tenant by kicking you out and just dealing directly with the people that you've introduced me to. That can happen. And then also, one of the things you want to consider is, what happens if your subtenant goes away? If you're the sub landlord, do you now have to go back into the premises and operate the premises? In an office, that might not be so bad. You could probably turn off the lights and just pay the rent. But if it's a retail operation, that's entirely different, because the value of a retail operation decreases dramatically once the lights are turned off. So there are other rights that you want to be able to retain as well, as I mentioned before, such as all of those tenant benefit clauses. So before you start the process, think through the process is the message I really want to give you, together with read and understand the provisions of the lease in its entirety, not just the assignment and subletting clauses.
Peter,
Howard?
why don't we talk a little bit about the difference between an assignment or a sublease? Because I think this is a good time. It may show up later in my PowerPoint, but
Sure.
as you're talking, I'm thinking of that.
Sure. So in the case of an assignment, what you're saying is that the person that you are assigning the lease to, the assignee or transferee, is going to step in place of the tenant. So they're as good as a tenant, they are the tenant. And therefore, you are sitting on the outside if you're the assigned or the original tenant, and you just get to watch what's going on. And you have some liability related to that. You don't have control over the space. You don't have control over the assignee or anything like that, unless you've got other documents that give you that kind of control. So you're assigning the lease, and it could be the whole of the premises, the whole of the term, just part of it. But whatever you're doing, you're giving up something. In a sublease,
Let me correct you there a second.
well, it
An
depends where you live.
assignment, yeah. An assignment is everything. You're
Yeah,
giving everything to the assignee. It will be all of the premises. It will be the entire term. We'll get
yep,
into the question of whether or not options to extend the term. But
yeah.
the main difference between an assignment and a sublease is that you're in an assignment, you're giving everything. You don't retain any rights to
Yep.
the premises. You just retain, in most cases, liability.
That is correct. There is a slight anomaly in at least one jurisdiction that I'm aware of, whereby it can be a partial assignment of the premises, and that came up in a bankruptcy hearing. So that got very complicated very quickly. But on a day-to-day basis, Howard, you're 100% correct. You're giving up all your rights to the space, and all you get is liability. In a sublease, now that's different. In a sublease, everybody is familiar with a residential sublease, I would imagine, and that is you remain as the tenant. The original tenant is remains as the tenant, and then there's just a layer that comes in underneath, which is the sublease. So the original tenant becomes the sub landlord, and then there's a sublease. The big thing here to bear in mind is that if the sublease goes away, the tenant, the original tenant, remains on the lease, but you have control of the lease completely. The other thing to bear in mind is that the sublessee must go through the sub landlord and can't go directly to the head landlord unless the head landlord has agreed in the consent document to allow that to happen, because you can't bypass. You don't want the sublessee to make arrangements that will affect the tenancy without the sub landlord, the original tenant, knowing what's going on. I know I'm using a lot of different phrases here because we use them interchangeably as we go through one of these documents that Howard's going to be talking about.
Now let's move on because we'll be talking about some more of this. So this is my section, and not just because I represent only landlords, but I just chose Peter to handle one end and me to handle the other. So, what should landlords consider by an assignment or sublease? Well, first of all, landlords want to maximize the amount of rents that they get. Period. I mean, you have to start from that perspective. And in order to do that, the landlords, if there is a proposal for a subtenant or an assignee, the landlord needs to be doing its own due diligence. It needs to check out the subtenant or the assignee. Are they going to be worthwhile? Is the landlord taking on more problems than they want to handle? Do they have the financial resources? So certainly the landlord shouldn't just say, oh, okay. And they, on the other hand, they may have obligations to delve into whether or not there's they can consent to a sublease or assignment. A lot of leases require the landlord to act reasonably. Since I go back far enough, there was a time where a commercial lease could only require the landlord to act reasonably. It wasn't in the landlord's discretion to act unreasonably. Well, that law has changed. So now what could happen is that I need to get rid of that ringing stuff. What the landlord can do in California is he can say, look, it's in my absolute discretion to consent to an assignment or a sublease. All right. However, if the landlord retains that right to turn down an assignment or a sublease in its absolute discretion, it does risk the ability to collect future rents should the tenant want to assign or sublease. As a result, many of the California leases have a list of things that the landlord can consider in terms of consenting to an assignment or sublease. And if they follow those and they are reasonable, then they can go after future rents should the tenant later default. All
And
right.
Howard, I'll interject 1 second here because I know you spoke specifically of California, but it isn't just California. I'm Canadian. I live in Canada. I work in Canada and the United States. And you should know that the things that Howard just mentioned about reasonableness are in English Canadian leases, not in Quebec because they have a different legal system in Quebec. I can't speak to that because I don't know what that is. But in English Canada, we follow British law, and very much like California, we can put in what is reasonable for the landlord to consider when considering an assignment or a sublease. So just wanted to point out that multiple jurisdictions may be impacted by what you say, Howard. It's not just California where you practice.
All right. So we're still on the issue of maximizing rents. What the landlord's going to look for is the new subtenant or S&E going to be able to pay rents? Who are you going to keep liable on the lease? I like to keep everyone liable on the lease when I'm representing the landlord because you never know what's going to happen down the road. And the more people I can look to pay the rent, the more likely the landlord's going to get paid. And I've handled hundreds, if not thousands, of landlord-tenant disputes. And trust me when I tell you, you never know. So the more change you got in your pocket, the more likely you'll be able to pay for something. The more guarantors you have. So you want guarantees. I'm not going to go into the issue of guarantees. Actually, that's for another webinar that I've got. And the landlord needs to pay attention to market conditions because you may have, as a landlord, this is the way I do everything. But you know what? Maybe I need to make an exception in this case, depending upon the market conditions. Maybe I don't need to be as tough as I used to be.
Can I ask you a question, Howard?
Sure.
From a landlord's perspective, what do you do about a subtenant that is paying the sublandlord more rent than that sublandlord, the original tenant, is paying to the landlord?
Well, hopefully there's a provision in the lease, the original lease, that says that that money has to be paid over to the difference has to be paid over to the landlord. If it's not in the lease and the tenant wants an assignment or a sublease, actually, we're talking about a sublease because an assignment, it all goes to the landlord. That's something that is often negotiated. If it's not in the original lease, I would go, okay, here's the deal. You really, really want me to consent to this. I don't have to consent to it, but you know what? This is what I want. Anything that you get in terms of consideration has to be paid over to me. So if the rent is $10 a square foot and you're getting paid 15, I want the 15. Sometimes that's a matter of negotiation. So while you may want the 15, you might be happy getting 12 and a half.
Yeah, I was just going to say that, I've often, from a tenant's perspective, negotiated a 50-50
Yeah,
split or a 75-25, whatever the case may be, depending upon how much leverage you have in it. One thing I want to point out, though, and it wasn't on my slide, but it was on your slide, and you made a good point of getting as many people as you possibly can on anything that happens if it's an assignment or a sublease. But bear in mind that often these leases, and I'm speaking from the tenant's perspective here, has that the assignor, and I'm talking specifically of an assignment here, will remain, and it doesn't say assignor, it says the tenant will remain liable on the lease for this assignment and any subsequent assignment. And there's no timeline on that. So
no,
you
no.
could find, and Howard and I have discussed this in other occasions, you could find that you're getting a phone call from a landlord that you've not dealt with in 20 or 25 years, and they're knocking on your door saying, pay up.
Yeah,
And so from a
that
tenant's
attorney,
perspective, you want to be very, very careful.
yeah, that attorney is usually me. And I can't tell you how many times that has happened, particularly during the recession. There were like 3 or 4 assignments. And so when I would, and the tenant owes $250,000. So I would say, give me all the leases and all the assignments. And
And
I
all the
discovered that
guarantors.
something's missing because the lease was dated 25 years ago, and there's still a number of options were exercised, et cetera. So let me take a look. And I go back to everybody. I'm sorry, but I go back and I got to tell you, you can hear the deadly silence on the other end of the phone going, oh, well, I assigned that ages ago. I said, yeah, but you still owe money on this. So let me move on to the other things. The landlord needs to pay attention to the tenant's use. That's very, very important, particularly in retail. Tenant mix in a shopping center is extremely important. But even in office or industrial, gross leases are really important. You want to know what the tenant's going to be using. So it's important to know what the use is. And this is something that, in representing landlords, I always tell everybody to do. I don't care how long the lease is, the landlord wants to try to retain as much control as possible for as long as they can. That gives them leverage. It doesn't mean that you have to exercise that control, but you have that option. And the longer the lease is, the more control. The more control you give up, the less leverage you have. And I just want my landlords to have the option of making a business decision and choosing what they want to agree to and what they don't want to agree to. You have
And I
anything
have
else to add on that
very
before I move on?
solid, well, no. I mean, I have some very solid thoughts on that from the tenant's perspective.
Oh,
You
yeah.
don't want to give the landlord control.
No, you want as
And
much flexibility as possible.
exactly. So I'll leave it at that because we got a
Yeah.
lot of stuff to cover.
Yeah. Okay, let's move on. Okay. Does the type of property make a difference? Peter, why don't you talk about retail?
The only correct answer in commercial real estate is it depends. And starting with that thought, I'll talk about retail. The type of property does make a difference. Because tenant mix is so important, it is often that in an assignment or a sublease that you can't change the use. And that's so that the landlord, to Howard's point a moment ago, retains control over the merchandising. The other thing that we have to bear in mind in retail properties is the exclusivity provision. And in many cases, that exclusivity provision may be personal to the tenant, but also it goes back to the whole use in the tenant mix and the assignment. And can you change the use from, say, a hair salon to a liquor store? Well, there may be problems with that because there may be an exclusivity somewhere else. Now, fortunately, in most retail leases, although it is at the time that the lease is provided, it may not be applicable 2 to 3 years down the road. There will be a list of exclusions that the tenant definitely cannot do. And that usually touches on the exclusivities or restrictive covenants of other tenants. Also, co-tenancy. The co-tenancy is important when it comes to both an assignment, a little less so in a subtenancy because theoretically the use doesn't change in a subtenancy. But with co-tenancy, what we want to make sure of is from a landlord's perspective, I'll speak from the landlord's perspective here, that you have those types of tenants that will continue to benefit the other tenants in the property. From the tenant's perspective, they also want to know that as they go through someone else's assignment or sublease isn't going to affect the co-tenancy that will diminish their business in the property. Howard, over to you for office.
Office. Well, I've already talked about the tenant's use and whether or not the tenant's use can affect the use of utilities, et cetera. So, for example, and I've because of my experience as general counsel for a vocational school chain, if you've got a full floor, 15,000 square foot tenant, and they're an office tenant, and all of a sudden you bring a vocational school chain comes in, you may have problems if it's in a Class A office building. That's number one. You may not want to mix those uses. Two, in a vocational school chain, there's a lot of attendance after hours. So there's going to be significant use of the HVAC. We went through that issue in Detroit and most other locations. So tenant mix in office, while it tends not to be as significant, it can be significant, and both parties have to pay attention to it. Let me move on to industrial. I mean, all of these, you have to pay attention to who the tenant is. I know that you have an example, but my experience has been twofold in industrial, where there's been a change in a tenant and change of use. Power usage, all right, because often there's a much heavier power load that is necessary to bring to the premises, so there can be a considerable expense changing the power. And parking would hold true, and industrial also traffic. Although honestly in industrial you're assuming that there is a lot of commercial traffic, but it may be different types of traffic. And you had an example, Peter.
Yeah, different kinds of traffic and things of that nature. I'll talk more holistically, though, about something that affects all of these asset classes, and that's just infrastructure generally. It could be waste removal, for an example, not just power. It could be in retail, and I'll also talk about one of the other infrastructure things when it comes to offices in a second. But in retail, if you have a use and you're changing the use because of the assignment, which generally doesn't happen. But if it did, let's say you moved to a restaurant and they were upstream of the water supply of a hair salon downstream, and they start swiping all the water, and all of a sudden you have a trickle of water down below because you haven't made adjustments to the infrastructure. So we have to look at all of the infrastructure implications, and traffic, and as Howard mentioned, and parking. If all of a sudden your parking requirements change, that you've got a cinema or a restaurant being a parking lot hog, then you need to bear that in mind. And in office, one of the things I wanted to mention about tenant mixes compared to infrastructure, but it does have an implication on infrastructure as well, is be particularly careful, and this is from a landlord's perspective, of government leases, because most government leases allow the government to put in any aspect of the government in that space. So you could have something very innocuous, low intensity use, and then all of a sudden you have family services or the probation office or something else that you may not want to have in your building. And in all these cases, if you have a building that is built to a sustainable level, such as Leeds or one of the other ones, and you change the power use, the density, as Howard was mentioning with the vocational school, it's a very dense use. You get a lot of people in there. Are you going to be offside with your sustainability goals? So those are things to consider. So look at the infrastructure and the implications of the assignment or the sublease to the infrastructure.
Absolutely. Whoops. Let me kind of move on now. And let's talk about the most relevant lease clauses, because people have tenants and landlords often have the mistaken belief that they only have to look to the assignment and sublease clause. All right. And some of the assignment and sublease clauses that I look at have multiple sections in them. I'm kind of stretching things out. It's like, and it's complicated alone. So we're going to start with the most obvious, which is the assignment and sublease clause. But there are many, many other clauses that affect the ability to assign or sublease, or the requirements, or are affected by. So why don't we move on? Let's talk about, Peter, triggering effects or events.
Well, the question is what causes an assignment or a sublease, I guess, is what a triggering event is. And generally, it's some form of transfer of the ownership or control. It could be a percentage. It could be as low as 25% change in the voting structure. It could be the sale of assets, a bulk sale or something of that nature. And it could be financing, by the way. It could be financing that triggers an assignment if they've pledged the lease, for an example, to the lender. So you want to negotiate some exceptions. So for an example, the obvious ones, if it's a publicly traded corporation or a widely held corporation, or even just a mom and pop, any subsidiary, any parent, any related party. But also don't forget about limited partnerships, or the death of a sole proprietor, because all of a sudden the lease will transfer to the executor or executrix. It transfers to the estate as an asset. So there's all kinds of triggering events. Just be aware of what those are from both the landlord and the tenant's perspective. The landlord may get this innocuous letter saying that we're pleased to announce that we've merged our company with XYZ. That's an assignment. You want to delve into it. From the tenant's perspective, you want to be able to know what could potentially cause an assignment or a sublease and negotiate out those exceptions. Blood relative might be something you want to look at. I know of a case, and this is relative to something else. Howard and I were talking about it beforehand, where there was a death in the limited partnership, and that affected an assignment, and the tenant lost a benefit clause that they had because the landlord said the tenant isn't the tenant that we originally signed up with. And I don't agree with that, but that's the way the courts went on that one. So there you go.
Let me add something there. I didn't write this on the PowerPoint, and I probably should have. I like to use the phrase management and control. And the reason why I do this is back in the 80s, when I was general counsel for Big Bear Markets, we had a chain of restaurants called Cook's Markets. They were like Norms. And because of it, I believe we owned all of the real property that they were on, but we were in the position where we couldn't sell all of the restaurants right away because we were transferring the liquor licenses. So we had to allow some of the liquor licenses at the time to mature. So instead of selling them, what we did is we entered into management agreements with an option to purchase the restaurant at a later time. Now, I've got to tell you here, this was, there we go. This was at a time where we weren't computerized. So it was like 18 restaurants. And I mean, the stack of documents to sign was crazy.
Yeah.
And we got around the requirements because we did these management agreements. So that's one of the things that you have to pay attention to. If you're the landlord, you want to be able to include management or control of the operation, which is very, very important because people like me will be creative and try to get around whatever the limitations that you put into the lease. Now, sale of assets. That is, I have seen it so many times, and you had asked this question of me earlier. What was the question that you asked me? Should the landlord look at what?
Should the landlord look at the purchase and sale agreement between the business vendor and the business buyer?
And the answer to that is absolutely.
Yeah.
Because what will happen is, and I've seen this, where the business would be sold for $1 million, but the assets are only worth $10,000, because this is such a valuable location that basically they tried to get around the lease thing and the delta between what the landlord is receiving, or the rent that the landlord is to receive, and what the tenant is paying. So often these are written in the form of, I got to get rid of that ringing thing. I don't know if you could hear it. Could you hear it?
I can't hear it. No,
Good. I can hear it. So often people will try to get around things, and I've seen all kinds of stuff. So sale or transfer of assets, a certain percentage, that's often what's, comes into play, and you'll see all kinds of stuff. Understand that an assignment or sublease does not have to include the sale of a business or assets. It could just be, I hear, take possession. That's
Yeah.
all that I want you to do. Now,
Well,
let me
in
talk.
some cases, for an example, although smart landlords don't allow this, but if a developer is swiping a tenant from another building, the developer may say, "Look, I'll take over your existing lease because the timing doesn't work out, and I'll just become the subtenant or I'll become the assignee." A good landlord won't allow that because then you're letting the competition in under the tent.
Sure,
It's kind of like a
sure.
Genghis Khan move. But they'll just say, I'll reimburse you for the rent. You're still on that lease over there. So yeah, we've seen all kinds of ways that people get around the actual wording in the lease. I'm glad you brought up the whole management thing because I've seen that as well. And but
I've
bear in
used it.
mind, yeah, you know what? And I haven't. I've been on the landlord side of that. But bear in mind, if you're the tenant, there is also a liability with that because you're still the tenant on the lease, even though there's a management team over there, and they better be really good. Otherwise, you could find yourself in a big problem. They could kill your business, and
Yeah.
then you have to start from scratch again. Hey, let's talk
Will,
about recapture provisions that are in there.
yeah. Did we talk about consent?
Oh no, we didn't. Let's talk
Yeah,
about
let me
consent
let me
first.
deal with consent, and I'll let you handle the recapture provisions. In most cases, landlord's consent is required. In most cases, if landlord's consent is required before the assignment.
Yep.
And in many instances, if you don't obtain you're the tenant and you don't obtain landlord's consent before the assignment or sublease, in California, I know for certain in many other states, it's considered an incurable breach, which becomes very problematic and very difficult for the uh, uh, for the tenant. And let's talk about briefly an intentional or inadvertent waiver by the landlord. I have been concerned about this in a number of the cases that I've handled. Fortunately, we've gotten away with it because I misdirect people in another direction. But I've seen it where the landlord would start receiving a check under the name of a different tenant and never question it. And the property managers need to pay attention to stuff like that because all of a sudden, you know, uh, uh, I get involved in the matter. I'm going, who's this? And they
Yeah.
go, well, let's kick them out because they shouldn't be there. I said, well, have you been accepting rent? And I know that the lease will say no waiver, accepting rent from someone is not a waiver, but boy, it starts making the litigation more expensive and problematic. So let's talk about recapture provisions because this is, again, an issue of control by the landlord.
Yeah, so the landlord, in a lot of instances, will have in their assignment and sublet clauses. And by the way, to Howard's point of these great big long clauses, yeah, I've seen them where it's assignment and sublet in one section, and then I've also seen it where there's an assignment section and then a sublet section. So in the recapture provisions, generally you'll find it under the assignment part as compared to the sublease, and it says the landlord can take possession and deal directly with the assignee or anybody else he wants to. That's in a hot rising market. Yeah, I don't think COVID's going to allow for a lot of that today. And as Howard mentioned at the very beginning, excess rents, tenant can't profit. They're trading in the landlord's real estate. The lease specifically says you cannot do that. And again, we talked briefly about the sale of assets versus excess rent. Howard had that beautiful example of a $10 million for a $10,000 transaction, or whatever the numbers were. We've all seen that happen on the landlord side. Any of those things will provide that the landlord could recapture the premises. One thing, and I don't know where it is in your slide deck, Howard, but I'll bring it up now, and that is with respect to being able to exercise an assignment in the first place. What do you need to do? I'll just briefly say, generally speaking, landlords will not allow a tenant who's in default of their lease to exercise an assignment or a sublease. They want everything brought up. And it's kind of oxymoronic in some cases. If the tenant's not doing well and they find someone who's going to do better, uh, it, you know, they are requiring that the lease be brought up to date in order to sign to the better person. So the landlord may make the business decision, notwithstanding anything else, to recapture that lease, deal with the other tenant, the assignor, and then deal with the assignee in a different way. I phrase that wrong. Deal with the former tenant one way and deal with the new tenant another way after recapturing that lease.
Now, during the recession, I negotiated a lot of these deals because I was representing a special servicer after foreclosure, and that's one of the things that we wanted was bring the lease current. If we could
Yeah.
get 100 cents on the dollar, we would push to do that. And often, as part of the obtaining our consent to assignment, we're basically having the new tenant pay us and bring everything current. So that a lot of that will happen, but it depends upon the circumstances and what you can negotiate. And I don't think that there's a set way to negotiate this stuff. Is like if the tenant owes $100,000 and you can get $75,000, up front for consent to assignment, the landlord generally is going to be very interested in consenting to an assignment, particularly if the new tenant has got the wherewithal to pay the $75,000. And what I try to do is negotiate. I tell you what, that $25,000 is still owed. I will give you the opportunity over a period of time to pay it back. I mean, I will try to get 110% of whatever is owed. All right. And be happy if I can get 100% or 90%. But, it's what I used to tell the kids I used to coach in basketball. We practice to win by 150 points and be thrilled if we win by one.
Yeah, exactly.
So let's move on. Okay. Use clauses. This is my favorite. And I've written on use clauses in your book.
Yes.
Use clauses affect whether or not you can assign or sublease. Landlords love to narrowly limit what the tenant's use is, sometimes unnecessarily so. Sometimes, and I'll give you a perfect example, I just negotiated a lease for an insurance agency, and the landlord wanted to limit the tenant's use to an insurance agency. And I'm going, no. So how do I respond? I respond and say any legal use. Truthfully, I know that it's reasonable for the landlord not to allow any use. So I said every use, knowing that there would be some reasonable limitation. So you may not, in those premises, you didn't want to have a restaurant. So you could have certain exclusions, but you want to make it as broad as possible if you're the tenant, and you want to make it as narrow as possible if you're the landlords.
Yeah, very much so. And bear in mind that the use clause does affect the assignment if the assignment wording says you can only assign to a similar use clause. And there may also be other provisions in the assignment clause as well, saying that the proposed assignee or sublessee must have a certain amount of experience in that specific use clause. So once again, if you get a very narrow use clause, that could limit the type of people that you could potentially assign or sublet your premises and your lease to.
And in retail, it's particularly important because there may either be exclusions, or even if there aren't exclusions in other tenants' leases, you want to maintain a certain tenant mix, because the proper tenant mix is going to increase foot traffic, hopefully, and increase the value of the shopping center.
Very much so, and we could write an entire book just on use clauses, and on topic for another day, but it is the least negotiated clause too often by unsophisticated tenants, and
Right.
needs to be negotiated more.
Let's talk about the lease term, the effect of sublease or assignment on the lease term.
Well, there's all kinds of things there. One of the things I want to point out, at least in the jurisdiction that I operate in, which is Canada, that according to a legal ruling, and I'm not providing any legal advice here, just information, that this came out of bankruptcy, and this comes to something that we talked about right off the top, where Howard corrected me on an assignment, that a sub landlord, the original tenant, must reserve some part of the lease to themselves. And generally speaking, what we do in Canada is we reserve the last day of the term to the sub landlord. In other words, the subtenancy agreement must end one day before the end of the initial term. Otherwise, it's an assignment. And so we want to get that clear. So again, you have an assignment. There might be an early termination clause that's proprietary to the particular original tenant that may not flow all the way through. Also, if you have those kinds of clauses in there that adjust the term, if there is a guarantor on the lease, I'm speaking from the landlord's perspective here, make sure that the guarantor is fully aware of all the things that are going on. Otherwise, you could lose the guarantee. Options. Is it transferable? Generally speaking, a lot of landlords say, I'll give you the option. And that's I call a tenant benefit clause. It only benefits the tenant. The tenant is the only one that gets to exercise an option to extend or renew the term. So the landlord is going to take it or give it to you and then take it back. And by taking it back, they're going to say it only applies to the original tenant. I don't want to give 15 years worth of term to someone I don't know, is their rationale. From the tenant's perspective, if you're coming up to the last 18 months of the term and you've got an option, you want to be able to say to the assignee, oh, guess what? You get that. Or subtenant, you get that. And so many leases say that the tenant can't assign or sublease in the first 18 months of the term to stop flipping the landlord's real estate, and in the last 18 months of the term. And so you could find yourself in a position where you can't sell your business.
Yep.
And it's as simple as that.
Absolutely. Okay. Exclusivity and co-tenancy. Why don't you go ahead and handle that also?
Okay, well, predominantly in retail leases, because you'll find it mostly in retail where you don't want 15 coffee shops in a 15-store strip shopping center. So the landlord wants to be able, as Howard said, to always control the merchandising, because merchandising is the lifeblood of retail properties. So your use clause and your exclusivity will determine who you could assign and sublease to. You have to be aware of not only your use clause, but also any restrictions that the landlord's given away to anybody else if you have the ability to change the use. Exclusivity, as you see on the screen, says that it limits what can be sold. And we talked briefly about it, and I don't want to go on and on and on about it, but use clauses can be overwritten or underwritten. Either one are both bad. You want something in between. And then we also have the whole concept of co-tenancy, which I touched on earlier. So no need for me to go any further on that one.
Okay, let's move on. Expansion and relocation. I see this both in retail, industrial, and office. Expansion. Let's talk about expansion. In expansion, basically, it is negotiated in the original lease that the tenant can expand during certain times into contiguous space. It's usually contiguous space. And it may include certain costs associated with it. So, with our vocational schools, we used to negotiate the right to expand in office buildings where we didn't have a full floor. We would want to expand to the full floor, at least the option or a right of first refusal to do that. That may not be something that's transferable in an assignment or sublease. So again, in all of these, you have to look at the lease and make a determination if these things are transferable in an assignment or sublease. And in an example of a vocational school chain, that could be very, very important. Let's talk about relocation a bit.
So go ahead, Howard. You start on that
Yeah.
one, and then I
It-
do want to bring it back to one thing that I was speaking of a moment ago with respect to exclusivities, but it also
Go
applies to
ahead.
expansion, and it applies to anchor tenants and the wording. And there's something you need to bear in mind if you're the tenant. If you were given an exemption to another tenant's restriction on expansion or on use, and you want to get that as loosely worded as you possibly can when you do the original negotiation. Often, if it's for an anchor tenant and they're giving up something, let's say, and I run into this with one of my clients, Anytime Fitness, fairly often, is that the anchor will say, I don't want a gymnasium or a fitness center in the property. So if we go in, the landlord would get an exception to that use, or will limit the size of the operation to, say, 4,500 square feet. And my client, Anytime Fitness, likes to go up to 6,000 feet. So here's the thing. Often what will happen is that the anchor will name the tenant to which they are giving the exclusion to. And so if you assign the lease to a new tenant, that exclusion goes away. And the anchor wants to do that so they have control. There's that
Sure.
big struggle of control between landlords and anchors. Forget about the ancillary tenants here for a moment. Landlords and anchors are in this perpetual struggle of control over the property. Anchors seem to think that they own it, and the landlords don't
Yeah.
want to give up any of that control.
Well,
So
it's
I just want to
interesting.
mention that. Watch for these other clauses beyond what we're talking about here.
Yeah, we could talk about gyms and supermarkets because parking becomes an issue
Yeah.
in those situations, but I don't think we should talk about it now. The relocation, I see that predominantly in retail shopping center leases, and it just amazes me how tenants agree to this. I mean, what they're most concerned about, what basically the relocation clause says, landlord could tell you to move your location. In retail, location is extremely important.
Yes.
So it makes a difference if you're on a corner, if you're not on a corner, in an end cap. And tenants all the time agree to this, and all that they're concerned about is the cost of moving.
Hmm.
It's like crazy stuff, but it's agreed to. So certainly if you're going to be a subtenant or an assignee, you want to look at the lease and see whether or not there's a relocation provision in retail. It's not as significant in office, but it could be.
Yeah.
So, for instance, a Wells Fargo branch bank is on the first floor of a office building. They don't want to be moved to the fourth floor.
No.
It's like, yeah, if they're a industrial bank or something, they may not care. But there are some office locations and even industrial. I don't think I've ever seen it in industrial, or warehousing, but it could be. But I think it's predominantly an issue with retail and then some office. Okay, you there? I lost you, Peter. Hopefully you'll come back. Okay, I'm going to talk about guarantees. We're going to have a separate webinar on guarantees in various parts of the country and the world. Hopefully you'll come back, Peter. So the guarantors should consent even if they have waived the right. All right. And this is important. In many, many guarantees, there's a waiver of every statutory right imaginable. And so the landlord and tenant can change the lease. I think Peter will be coming back in, hopefully. I heard that on this occasionally there was a problem. There's Peter. Come on back in. You there, Peter?
Yeah, I'm here. Ecamm kicked me out for a moment.
Yeah.
I
Oh,
don't know
that's
what happened.
okay. Yeah, they occasionally have that problem, from what I understand. So I was talking about guarantees, and I've
Yes.
kind of moved on. You want to make sure that the guarantor is not being released in whole or in part. And if there are any changes in the lease terms, basically the bottom line is whether or not you have the right to make changes or not, you want the guarantors to acknowledge whatever the changes are. Period.
Very
You know,
true.
be on the safe side. Okay. A little bit of pixelation here, Peter.
I see that.
Yeah,
It's
that's
not on
okay.
my side, so.
It's a good look for you. Very nice. Okay,
So
let's get to typical transactions and structures. And I know this is some
between the assignor and the assignee, or the sublease document between the sublessor and the sublessee, is also signed by the landlord. What I'd like to see is I like to see those as separate documents, because there's different things that you want to have in there, depending upon who the parties are. So what I prefer to see is a separate assignment and then a separate consent to the assignment, or the sublease and a separate consent to the sublease, because there may also be amendments to the lease that a savvy assignee or sublessee even can negotiate into the document. So and that would be covered under the landlord's consent and lease amending agreement. And I apologize for the pixelation. I do not know what's going on. I have Ethernet and everything's good on my
no,
side. So
who knows what it is. I wouldn't worry about it.
okay.
Yeah,
So,
go ahead.
and then the other thing that I want to talk about is that the transferee will want to indemnify the transferor for the reasons I pointed out beforehand. In the case of an assignment, you only have the liability. I think Howard actually mentioned that. You don't have any of the benefit, you just have the liability. So the assignor
Let's
will.
clarify that for a second. If you're the tenant and you assign a lease to a third party,
Yep.
this may vary from different jurisdictions, but for the most part, you no longer have any rights to the lease. You no longer have any rights to possession unless you retain it, and you can negotiate that, by the way.
Right.
All you have is this liability. It's a terrible situation to be in.
Yeah, very much so. It's horrible because all of a sudden, you could be sitting out there on the beach somewhere and you get a phone call from Howard saying, you owe us $250,000. And then you have no idea of what's necessarily happened. So you want to have in the agreement for the assignment document, I'm not providing legal advice, I have to say that because I'm not a lawyer. You want to have that ability to claw back that liability from the assignee. In other words,
We
you
see
put it
that
on
often.
them.
Yeah, we see that often in franchisor and franchisee situations where the franchisor becomes the original tenant. Then they are released from liability when they when they get a franchisee that takes over the operation. But then they also often negotiate a situation that if they consider the location important, they're given the opportunity to take back the premises if the franchisee fails or defaults. Franchisor takes possession over, runs it until they find another franchisee. I've seen that happen
Yeah, and then
quite
it's rinse
often.
and repeat on
Right.
the franchisor's liability. The last thing I wanted to mention on this one is that actually I should give it over to Howard, but it's at the very beginning of the document. There should be a recital very similar to an estoppel, so that everybody knows the lease is in full force and effect. This is the only document. The rent has been paid. Blah blah blah. So basically, pick up this estoppel wording.
Yeah, and this is what I like to do. The tenant and the assignor, or the tenant and the sublessee, they negotiate their deal and then come to the landlord and say, "This is our deal. Will you consent to an assignment or sublease?" And at that point in time, depending upon the situation, the landlord may say yes, may say no. If the landlord says yes, then there's a separate agreement that's consent to assignment and attaches all of the other documents between the assignee and the assignor, or the sublessee and the sublessor, to the consent to assignment, so we know what the landlord is consenting to.
Yeah.
All right, and that's important. But often it's an opportunity for the parties to negotiate. First of all, for the landlord, you want to go, okay, here's what you owe. This is the rental term. This is the amount of rents, yada, yada, yada. You want to establish it. You want the tenant to say, and the landlord is not in default. You want to establish that, just like in an estoppel certificate. And sometimes when the tenant comes to the landlord for its consent, the tenant is in default. So it may be an opportunity for the landlord to negotiate something to try to recoup some of the losses from the default. So it's not unusual for the consent to actually include an amendment to the lease, which often I create as another document.
Right. A
Just
lease
so
amending
that
agreement.
things, right. So
Yeah.
in any event, so let's move on. That should be pretty much it. So I'm going to get rid of our pictures here. And so this is what we're seeing. We'll just move on. It'll be in the repeat so you can see more about me. And here's my contact information. And the same thing for Peter. You look a little different. You look a little tanner in the picture, Peter.
Well, one was outside, one was inside.
And it says for 30 plus years. You've been doing this almost 40 years, haven't you?
Just now over 40 years. You have to update that slide.
You must have started when you were 6. Okay. And then here's Peter's contact information. Did I lose you again, Peter? Well, I lost Peter again. He froze on me. I'm sorry to say that. So on behalf of Peter, Morris, and myself, I'd like to thank you. And let's see, we have a CRE TV live. It looks like this may not have live streamed, so this will be a repeat. So once again, thank you very much, and you have a great day.